Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, it shall be heard. God save the United States, great state of Florida, and this honorable court. Ladies and gentlemen, Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. The first case on our docket today is the state of Florida versus Poole.
Good morning. I'm Scott Brown, representing the state of Florida. May it please the court. The state appeals the order vacating Mr. Poole's death sentence below on the basis of Hurst error. However, Mr. Poole entered the penalty phase for his resentencing eligible under Florida and United States constitutional law for a death sentence. He had prior violent felony and contemporaneous felony. This court had previously held for more than a decade that these convictions took the case out of the purview of Ring and Apprendi. However, when Hurst v. Florida was remanded back to this court for a very limited question, harmless error, this court employed that decision to implement additional requirements that were not required nor even suggested by the Supreme Court in Hurst v. Florida. In fact, the ruling from the Supreme Court was a very narrow one. They overruled Spaziano and Hildwin to the extent that it allowed a judge sitting alone to find an aggravating circumstance that rendered the defendant eligible for the death penalty.
Doesn't the Florida Constitution permit this court to exceed in affording citizens' rights of what the Supreme Court requires?
Your Honor, that is correct. However,
so what you're saying then is that when you say that we exceeded the mandate of the United States Supreme Court, you're saying that we did that. You're not saying that we could not do that.
Actually, I am in part, because when you reference the Eighth Amendment to justify that decision, Your Honor, there's a conformity clause.
Are you saying that we violated the conformity clause? Did we cross that line?
Yes, Your Honor, because remember, Hurst v. Florida was a Sixth Amendment case. Now, when it was remanded back, you employed the Sixth Amendment, but you also brought in the Eighth Amendment, which applies to the selection and narrowing function. Now, when you say it's a matter of state law and state constitutional law, this court should be able to cite to something in the Constitution, our statute, or our case law to support that decision. And that's the problem. When you just say it's a matter of state law, there's nothing in the state constitution that says our right to a jury trial includes jury sentencing. There's nothing in our history surrounding jury trials, and in particular in capital cases. Remember, pre-1970, a death sentence was automatic unless a majority of the jury recommended mercy. So I don't know where this court found that matter of state law, because it doesn't appear in either our decisional law, the Constitution, and certainly not the federal Constitution. Now, it's time for that precedent to be reconsidered, because, Your Honors, this court, this decision in Hurst v. State is on an island with Delaware. Virtually every other court, including federal courts of appeals, have rejected the notion that balancing and weighing are required eligibility findings under the U.S. Constitution. So the state is asking this court to recognize that error. It's not supported in case law, and it would be consistent with this court's prior case law that said Ring Apprendi is satisfied if there's a prior violent felony or contemporaneous felony.
Any of those other states that you're referencing have the statutory scheme that we have, where the findings on the aggravators are not made during the original trial. They're made during the penalty phase.
Yes, Your Honor. In fact, most states are similar to what Florida employs, because remember, there's that capital, the first-degree murder conviction, plus at least one. So I'm talking Alabama, Ohio, Kansas, Missouri, every federal court of appeal to determine it, including the 11th Circuit Court of Appeals. So again, that rationale is much more sound. So I think the state has offered up special justification in this case to reverse that portion of Hurst v. State that mandated findings that are not required by either the state or U.S. constitutions. With regard to the alleged McCoy-Nixon error in this case, Your Honors, unlike the situation in McCoy, Mr. Poole voiced no objection at the time of trial to Mr. Dimig, his experienced trial attorney's intended strategy. Remember, Mr. McCoy voiced an objection at every opportunity. In fact, he sought to discharge his attorney. And Mr. McCoy's record on direct appeal supported finding a structural error. So that is why the Supreme Court said you do not resort to Strickland. It is a structural error apparent from the face of the record. However, in contrast, here, again, Poole was silent. And at the point in time, the most important...
You say he was silent. Didn't counsel say that he had repeatedly told counsel he did not want to confess or to admit that he had committed the offenses?
Correct, Your Honor. And what I meant is silent on the record. So Mr. Poole didn't, when Mr. Dimig explained, hey, look, there's overwhelming evidence supporting your conviction here, including DNA that excludes anyone else. I mean, his DNA was in the 18-year-old pregnant victim to the exclusion of anyone else on this planet. So there is absolutely overwhelming evidence.
But is it your position that McCoy is distinguishable based on that? Because the attorney for Poole testified that Mr. Poole was adamant that he not concede those charges, the non-homicide charges.
Well, I think you have to look at tactical decisions raised. At the point in time when Mr. Dimig explained, before getting up in closing argument, he took Mr. Poole aside at counsel's table and explained to him, look, this is what is left to me. This is what I'm going to make that concession. Mr. Poole did not respond like Mr. Nixon.
But in fairness, in the testimony from Mr. Dimig, didn't he say that basically he's getting ready to stand up, and he's telling Mr. Poole this, and there was no, as I recall from Mr. Dimig's testimony, he said there was really no opportunity for Mr. Poole to respond other than by acting up, because he didn't ask him. He told him, I'm doing this, and then he stood up and did it.
Well, he explained to Mr. Poole that this is what is left to us at this time. So, Your Honor, I appreciate that. This isn't exactly like Nixon, but it's not like McCoy either.
Let's go to the preservation issue, if we could. Explain why. I mean, it's your position that this was not preserved.
That's correct.
It was not presented properly.
Yes.
In the post-conviction court. Would you explain that?
Yes, Your Honor. The motion itself references two claims under Strickland. That the attorney's comments violated Mr. Poole's right to remain silent and also violated his attorney-client privilege. It did not say it violated his autonomy. It did not say that, did not actually present a McCoy issue. It conceded that Nixon and ineffective assistance of counsel was the appropriate review. So I submit that you can't wait until closing argument and again, there was no motion to amend at the time. Were we aware that this was going to be an issue, what counsel's advice was? Certainly, and there is a factual basis in the record. But it has to be properly presented to the lower court in order to preserve the issue. But again, I think the stark contrast between McCoy here mandates different treatment. Again, McCoy was a direct appeal case, and the Supreme Court has said in Weaver versus Massachusetts that you aren't entitled to a structural error review if you wait until post-conviction to raise that claim for the first time. So the proper standard here is ineffective assistance of counsel. And Nixon governs. And also there are other...
What about just waiver? At any time, let's go back to the direct appeal. At any time, it's on. There you go. At any time, did the court? I mean, some of us here have been trial court judges and have dealt with death cases and have dealt with these situations where a defendant is choosing not to testify, or whether a defense is going to be presented, and the trial court would take the time to ask. Excuse the jury, and Mr. Defendant, your lawyer claims that he's about to confess to the jury that you did this, and you did that, and you did this. You're in agreement with that strategy. I mean, some judges would do that. And your position here is, well, the defendant never raised it down below. Well, when would he have had that opportunity if he was not asked to do so?
Your Honor, Mr. Poole was an active participant. He was polite, respectful, and he had multiple conversations with his attorney. If he had irreconcilable differences with him, just like the defendant did in McCoy.
But when would he have done that in particular in this case? Because the defense counsel testified that, in essence, he told Mr. Poole that he was about to concede this when he was about to stand up to do closing. What was Mr. Poole going to do? Start flaying and saying no in front of the jury? I mean, he's not going to ask the trial court judge for a sidebar.
Your Honor, he could have said no to Mr. Dimmick. He didn't. He was unresponsive, just like Nixon.
But he did say no to defense counsel. He was adamant that was not a strategy that he agreed with. The issue is that the trial court was unaware that Mr. Poole did not agree with the strategy of trial counsel to concede the non-homicide charges.
Mr. Poole did not bring that to the court's attention. Again, I think why the state presented all of the colloquy below is because there is a difference of opinion as to what Mr. Poole and Mr. Dimmick said. You can speculate that Mr. Poole was non-responsive and he just held his earlier position, or you can agree that Mr. Poole, having sat through trial, hearing all the DNA evidence, including passing stolen property with his blood on it,
okay,
and having absolutely no defense.
I'm sorry to interrupt you, because I think we understand your views on trying to distinguish Nixon and McCoy. So if we could move, though, to the issue of whether we should be viewing this through the Strickland lens or whether we should be viewing it through some other lens, and specifically with the issue of whether there's a need to show prejudice at this point.
Well, it absolutely not, Your Honor. The question of prejudice, and that's why the defendant is so insistent that we view it as a structural error, because you didn't hear one argument about an alternate defense. At least in McCoy, he had an alibi. Mr. Poole offered nothing, either at trial or in post-conviction, to challenge any of the compelling evidence against him. So when he argues that another course should have been taken, what was it? Nothing. Nothing in his brief, nothing has been argued. So if it is viewed under Strickland as is appropriate in this case.
So what do you make, can you help us understand, though, the part of McCoy where the court says that because the competence of counsel isn't really the issue in a situation like this, that we shouldn't be looking at it through a Strickland lens? I understand that that was on direct appeal, but I mean, is that the reason why you're saying
yes,
this isn't?
Your Honor, and I think there are unique facts, and again, I think McCoy is going to be limited to the very extreme facts in that case, where the conflict is apparent from the direct appeal record that both counsel and the defendant sought to end their relationship.
But I mean, let's assume that we disagree with you, and obviously I'm not speaking for anyone, including myself, but let's assume that we aren't persuaded by the argument that the client didn't go along with this, that we don't accept the distinguishing Nixon issue. Can you just please address the McCoy and the prejudice point?
Yeah,
and how we should be looking at
I think
that?
I did. I think when you raise an issue on post-conviction because of the finality interest. And again, I'm relying on Weaver versus Massachusetts, which I submit is directly on point. If you raise that claim as a matter of ineffective assistance, though if you had raised at the time of trial, it may have been a structural error, we still need you to show deficient performance and prejudice. And again, I think there are other significant differences here. Remember, what trial counsel did in this case is he didn't concede the murder and attempted murder. He had a theory, maybe not a compelling one, that they were separated in time. So he, unlike McCoy, he didn't plead his client guilty at the time of trial. So if we're expanding McCoy to cover routine tactical decisions on lesser offenses during trial, I would say that the Supreme Court perhaps has opened a can of worms. But I suggest to you that the more narrow ruling, that it is a rare case that can be raised on direct appeal that shows a conflict, an active conflict between counsel and his defense lawyer, and that is when McCoy will control. And again, if I see that I have, I'm running.
You've used all your time plus a little bit. I'll give you 2 minutes for rebuttal.
Thank you, Your Honor.
May it please the court, Julius Chen on behalf of appellee, cross-appellant Mark Anthony Poole. I reserve 5 minutes for rebuttal. If I could start with the McCoy issue and just make 2 points about what happened prior to the closing argument. I would point the court to the record at ROA 1548, where Mr. Dimmick testifies very clearly. At any time did Mr. Poole abandon his objection to you conceding guilt to the non-homicide offenses? Not that I recall. That means that he understood that Mr. Poole, in the exchange in which he told Mr. Poole, not discussed the issue with him, he told Mr. Poole that he was going to concede guilt, and split seconds later walked up to the podium to concede guilt, that he did not even understand Mr. Poole to have abandoned his longstanding objection that he had raised at least a half a dozen times, including during the course of trial. And as a legal matter, I would just point to Nixon. Nixon refers to a situation in which you have consultation and then silence or acquiescence in the face of that consultation. And what the Supreme Court in Flores-Ortega says, when we talk about Sixth Amendment rights and we talk about consultation, that is a term of art. What it means is to advise a client and critically hear to discover the defendant's wishes. That was not done here. And so we think that the record can really only be done or read in one way, to say that there was an intransigent objection here, and that fits within McCoy.
What was the first point at which Mr. Poole raised and made the argument, raised the issue, made the argument that this was a structural error because it was his decision and not counsel's decision to make?
Well, Your Honor, he had always put in his claim that the concession of guilt was a violation of the Sixth Amendment. It was not framed in terms of the structural error in McCoy at the point in his motion. And what I would point out is that he referenced Nixon. There's no dispute about that. And I think what I heard counsel say earlier was that everybody was on the same page, that it was a Nixon-type claim at that point. But I don't think that should be a bar for this reason.
I mean, other than the reference in the motion, other than this reference at the end to Nixon, which seems almost like a non sequitur, well, I guess that's the point. It seems like a non sequitur. There's nothing before that that leads you to think that the type of error that is being talked about is the Nixon-McCoy error. Is there?
I would point to 2 things in the record. First, on that page of the motion at ROA 418, it references, of course, the violation of the attorney-client privilege. But what it says is it's not just that violation. It's that the violation protects other Sixth Amendment rights, including to right to legal representation, and it protects the adversarial nature of the proceeding, which was lost here. And then it cites Nixon. But what I think is more telling is that when the state responds, and this is at ROA 529 to 531, it fully understands the nature of the claim. It says that even without the consent of the defendant, and it cites authority for this point, that the concession of guilt can be made, even without the consent. And when you get to the hearing, you have 70 some odd pages devoted to the subject of whether or not Poole objected, what the prosecutor called a line-by-line explication of Nixon to determine whether or not it is distinguishable and whether or not it provided Dimmick the authority to concede guilt. And then you get to the closing argument where the state makes the exact same argument all the way through. It says at 1652, and I think this is a critical line, that Poole did not agree with counsel's strategy does not matter. So at all stages, the state was fully apprised of what the nature of the claim was. And to get back to the Nixon point versus the citation to the McCoy, I think it's notable here and instructive that even in McCoy itself, when it was in the Louisiana Supreme Court, it was argued as a Nixon claim. And it's not surprising that everybody would cite it that way. Nixon is the relevant authority at that point. People don't know what to do if it is distinguishable because there is an intransigent and express objection. But once that is made, that's essentially what this entire proceeding was about, to determine whether or not Nixon was distinguishable. And it wasn't until, of course, the U.S. Supreme Court said, no, we're thinking about this all wrong, even in that particular case, in McCoy's case.
Well, I'm just having a hard time. If you could point me to where in the motion you make the express argument that this is distinguishable from Nixon, and that's the basis for your claim.
Well, Your Honor, we don't make that exact argument. What we do clearly do is we put into issue the claim that the concession of guilt is a violation of the Sixth Amendment, and it cites Nixon. And again, I would just point to the state's response here. There is no confusion at all. And this record, to be clear, is tailor-made for McCoy in the end. I don't think it would serve the purposes of waiver in any way, shape, or form to say that this claim is waived. The state made every argument that it wants to make. It is continuing to make the same arguments here, and the court was fairly apprised. At ROA 1732, it makes a ruling. It says that Nixon gave Dimmick the, quote, authority to concede guilt. And so this was presented to the court, it was ruled upon, and I think it would be extreme formalism to say at this point that the state can say, you know, we made all of these arguments about Nixon. We think that the objection just doesn't matter. It has nothing to do with the authority to concede guilt. There are references throughout the record, throughout the hearing, throughout all of the arguments to the authority to concede guilt, and that issue was actually decided, and so there's no impediment to this court's review. There is a full record on which it can adjudicate the issue, and we think that it is fully preserved under state law. On the structural error point, I would just make...
Can you maybe distinguish, are you familiar with Deprivine versus State, where we said that where an issue was raised for the first time in closing argument in that case, that the court properly summarily denied it as insufficiently pled? I mean, how is this any different? Because the first time, as I understand it, that this argument was made was after the hearing and the closing statements that were filed.
Well, Your Honor, again, it's our position that the state understood all along, even before the closing argument at the hearing.
It's not about what the state understood necessarily, it's what you said in the pleadings and...
Well, Your Honor, we think that falls into a category of cases, including the Doorball case, I think, that is cited in the footnote of the state's brief, in which a claim comes out of the blue. And so you can't just go to a hearing and then say, oh, guess what, I actually have this other claim over here. We clearly have a dispute from the start. Everybody understands, again, that there is a challenge to the concession of guilt on Sixth Amendment grounds. Nixon is the critical precedent that underlies the parties' arguments, and they go forward on that basis. So to say that the state was not given notice of the nature of the claim...
I read your motion as essentially saying, yes, it was a strategy decision under Nixon, but it violated my client's right to remain silent. It violated these other rights. I mean, that's the way it seemed to be framed. It seemed to even concede that it was a strategy call when it was pled and at the hearing.
Well, Your Honor, what I would say, again, is that instead of reading this on a cold record and saying, well, what do we think that this motion says to us? Look at what the state did. The state had a full understanding the entire time. And to be clear, it objected, especially at the hearing, on, every other question that was raised for various other reasons, but it never, at any point, including in its written closing argument, said, hey, there's been a shift here in the nature of this claim. It didn't say that at all. It didn't say this is falling outside the scope of what was argued in the motion. It went along the entire way because, in its view, this was all of a piece. There was, again, a challenge to the concession of guilt, very clear, citing Nixon, and an argument about whether or not Nixon controls here and provided authority. And again, all of this led...
Assuming there was preservation and assuming there was error, do you agree that we still need to evaluate some form of prejudice?
No, Your Honor.
Then tell me how Weaver does not direct exactly that in the ineffective assistance of counsel context where there's an alleged structural error, and Weaver's statement on how the burden shifts from a direct appeal context, which McCoy was, to a ineffective assistance of counsel and collateral context, which we're in here.
Sure, Your Honor.
I know that's a lot. Go ahead.
No, yeah, so I'd start with the point that Weaver grapples with an ineffective assistance of counsel claim. We do not have an ineffective assistance of counsel claim here if you agree that the McCoy claim was preserved. What you have is an autonomy right which has a violation that is complete at the moment that Mr. Poole's autonomy is actually overrun. And so the reason that's critical here is that prejudice is an element.
I'm looking at page 15 of the motion. It says, trial counsel was ineffective for stating during closing arguments that Mr. Poole acknowledges his guilt for sexual battery, burglary, and robbery, thus denying his right to the 5th, 6th, 8th, and 14th Amendments.
That's correct, Your Honor, but I'm taking as your premise that we have preserved a McCoy claim in this instance.
No, my premise is you've preserved some form of it, but it's still an ineffective assistance of counsel claim, correct?
No, that's not correct, Your Honor, in our view. We believe, as in McCoy, that there was a reframing and a better understanding now of the nature of this claim. This claim is not an ineffective assistance of counsel claim. That's what McCoy holds very clearly. And given that it's not, then you don't have to go through the prejudice step because the prejudice step is only relevant to an ineffective assistance of counsel claim.
So I have to ignore exactly what you said in the motion?
Your Honor, even McCoy, again, was argued as an ineffective assistance counsel claim below, and the court fully...
McCoy was a direct appeal, though.
Well, that doesn't matter for the nature of the claim, I think, whether or not it's post-conviction review or it's direct review.
Except that Weaver says exactly that.
Your Honor...
Does Weaver say exactly that? That it matters?
Your Honor, it matters because...
Does Weaver say that?
Yes.
Okay.
In the particular context of a structural error that could have been raised on direct review.
Which is what exactly what this is.
No, Your Honor. No, Your Honor. In this case, we could not have raised this claim on direct review. This is the type of claim that gets developed in a post-conviction hearing. This happened in the Nixon versus Singletary case.
Except that it was raised in direct appeal in McCoy.
That's true, because there are situations, we think they would be rare, in which a defendant would somehow make a record. I don't think that's a requirement here. There's no dispute from the state here, at least. This is at the cross-answer brief at pages 30 and at 38 note 11, that Mr. Poole could not have raised this claim on direct review. So there's no end run. That is the animating feature of Weaver in this case. What Weaver says is we don't want a defendant to be able to escape rules of forfeiture and a waiver of a claim. And so that's not what is happening here. This was Mr. Poole's first opportunity to raise his claim under the Sixth Amendment, and he did it in a post-conviction proceeding as he was supposed to. Again, in Nixon versus Singletary, which gave rise to the Nixon case in the U.S. Supreme Court.
It seems like your argument, I thought your argument was you're making an ineffective assistance to counsel claim, but rather than going through Strickland, it's fundamental error because it's structural. Is that not that's not your argument?
Well, that is one of our arguments in our brief, but we think the primary barrier to applying Weaver here is Weaver says that you need to have a forfeited, essentially, a forfeited structural error that could have been raised on direct review. There was the public trial right that was not objected to, that was forfeited on the direct appeal, and then it is shoehorned into an ineffective assistance of counsel claim later on, because that's the only way that you could continue to pursue it. That's not the situation here. We haven't tried to shoehorn any claim that we could have raised on direct review into an ineffective assistance of counsel claim here. We now know that the McCoy claim is a Sixth Amendment autonomy violation. It has nothing to do with prejudice, and thus we think that once you accept that we have brought a McCoy claim, that claim needs to be adjudicated in the same way that it would be normally. It is not an ineffective assistance of counsel claim in which prejudice is an element of that claim and the violation is not complete until the prejudice is shown. The prejudice here is, the violation is complete here at the moment that the autonomy of Mr. Poole is disregarded by his counsel. If I could turn very quickly to Hurst. The state here says today that there's really nothing in state law. And just very quickly in my last 30 seconds, I point to two passages. First, in the U.S. Supreme Court, there is a citation at 136 Supreme Court 22 where it says the Florida sentencing statute does not make a defendant eligible for death until findings by the court that such person shall be punished by death. It cites Florida 775.0821, and then it says the trial court alone must find the facts, and then B, that there are insufficient mitigating circumstances to outweigh the aggravating circumstances. That we think is a clear citation to state law that provides the analysis under the Sixth Amendment here. That is echoed in Hurst versus State at 202 Southern 3rd, 51 to 53.
Okay, you used all your time. I'll still give you 2 minutes on your cross appeal rebuttal.
Thank you.
Let's just make, the state is standing by its preservation argument. It was argued below as ineffective assistance. It was decided by the trial court as an ineffective assistance claim. So the fact that the state, what the state might have understood about the claim is irrelevant. The claim was not pled with the specificity that Rule 3851 requires. One more point. At this point, when the tactical decision was made, go back and look at that transcript from the evidentiary hearing. Mr. Dimmick said, this is what is left to me, this is what I need to do. Mr. Poole didn't say no, he didn't object. The defendant is asking this court to speculate that his silence was a continuation of some vociferous objection to counsel's strategy like McCoy. You can't make that jump based on this record. So putting aside the moment, the different procedural posture of these two cases, the defendant has to have this court speculate that silence was continued objection, whereas I think, and the state submits, that the more likely or reasonable explanation is silence was Mr. Poole's recognition of the overwhelming evidence presented by the state at trial.
Again, I'm just caught up on this. When would he have had that opportunity if the defense counsel, let's say he discusses with him, the defense counsel and his client, Mr. Poole, talk about that, and then defense counsel gets up there and starts telling the jury, my client did this, my client did that, my client did this. Unless the judge at that point in time interrupts the argument, excuses the jury, and says, wait a minute, he's confessing that he's telling the jury that you committed those crimes. Did you two have that conversation? Unless that occurred, when would Mr. Poole have had the opportunity during the course of the trial to get up and say, no, I don't want him doing this?
I think Mr. Dimmick, may I just answer the question, Your Honor? I'm sorry. Mr. Dimmick answered that below. He said Mr. Poole didn't object, jump up and down, and say no. And then he went and gave his argument. So I think on these facts, it is easily distinguishable from McCoy. It's much more like Nixon. The state asks that you reverse the lower court order, granting a new penalty phase, but otherwise affirm. Thank you.
May it please the court, I just make one quick point on the preservation issue. What the state is essentially asking is for Mr. Poole to have had the foresight that McCoy was going to change the way that we think about these ineffective assistance of counsel claims, shifting it from a Nixon framework to a Sixth Amendment autonomy framework altogether. I don't think he should have been expected to know that going into his motion or any time during the proceeding that he needed to reframe. And again, this is a tailor-made record for a McCoy claim. There is nothing in this record. If you had gone back to the start, I think, and said, okay, we have McCoy now, how would we make a record? You would have precisely the same evidentiary hearing, you would have precisely the same arguments on behalf of the state, and the only thing that would be different in our view is that McCoy would have compelled the trial court here to reverse the convictions on all counts. That's the relief we're asking.
Well, I mean, you could have at least made the factual, I mean, the initial motion was arguing about not even so much the concession as the wording, you know, is the difference between saying I acknowledge that I did these acts versus I acknowledge that, you know, such and such has been proven as a matter of law. So, I mean, part of it maybe would have involved McCoy giving you the legal tools to be able to articulate the claim, but there's not even a sense factually in the motion that that your client was claiming that, hey, I objected to this approach and counsel went ahead and did it anyway.
Well, Your Honor, I agree that the motion is not a model of clarity, but what I will say again...
It actually is really clear. I mean, that's the problem.
Well,
if you contrast the initial motion with the closing argument, it's a stark difference. I mean, the closing argument presents it as, in fact, two separate arguments, either of which would allow you to prevail. And it's pretty clear if you put them side by side that in the first one you're only making the one argument about the way that it was phrased.
Well, Your Honor, just very quickly, I would again point to what the state did here. There was no objection from them saying that this claim has shifted in any way, shape, or form. And again, it would be extreme formalism to say that a fully litigated issue with the state making all the arguments that it wanted to make and the record that it wanted to make and the trial court actually ruling to say that this was not timely raised and that the court was not fairly apprised in this situation. Thank you.
Thank you.
Thank you.
The court will now move to the second case on today's